Today's contract tip has to do with making sure your clients understand the contracts. So here's what happened. We had a contract that failed to close. The buyer sent a termination and release agreement asking for the earnest money to be released to the buyer. The reason for termination was the buyer was terminating under the financing contingency. Now, this termination was sent the last day of the financing contingency, but there was no loan denial letter sent along with the TNR, which is a requirement in all of the financing contingencies to send that loan denial letter from the lender, proof from the lender that no, the buyer does not have the ability to get the loan. So the listing agent the next day requested the loan denial letter. Buyer's agent got the loan denial letter the next day, dated the next day. So number one, the loan denial letter was sent. The buyer did not fulfill the full requirements of the financing contingency, which was terminating and sending the proof that from the lender that they couldn't get the loan. Then on the loan denial letter, it stated that the reason the buyer could not get the loan was the buyer had insufficient funds to close the transaction. Now, if you go back and look at the financing contingencies, both on the GAR contract and on the RE forms contract, you will read and remember and know that lack of funds to close the deal is not a reason. That does not meet the terms of the financing contingency. So right now we have a buyer that has defaulted on the contract by means of terminating the contract under a contingency, not meeting the terms of the contingency. So the seller does not sign the release agreement, comes back to the holder to decide what to do with the earnest money, because now we have earnest money in dispute because the seller won't sign it. So based on all of the issues I just outlined, the holder determines that the earnest money is to be released to the seller. In this notice regarding the 10-day letter, which is the notice regarding how the earnest money is going to be released, there's a statement that says, should the parties sign a fully executed termination and release agreement to release the earnest money, then the holder will release it immediately upon receipt of the agreement rather than waiting the 10 days. A few hours later, the holder receives directly from the seller, not the listing agent, but the seller. Now, the holder, it represents the buyer. The holder is the broker, the buyer's broker. So the holder receives directly from this. Okay, let me back up. So the holder sends this notice to disburse funds, sends it to the actual public buyer and public seller through certified letter with return receipt requested. So sends it that day. They have not received this information other than from their agents, because the holder sent this notice to the agents and the brokers with an email. So a few hours later, the holder receives an email directly from the seller. Now, the only way the seller can ever knows anything about the disbursement is directly from the listing agent at this point. So receives from the seller a fully executed release agreement releasing the earnest money back to the buyer. So either he changed his mind, but it appears right now he changed his mind, because this was the release agreement that was originally sent, and the seller has signed it. Who knows? Maybe he changed his mind. Maybe he saw that because the buyer lacked insufficient funds, he didn't want to take the $5,000. It's Thanksgiving. Who knows? 2 hours later, the holder then receives another email stating that that was a mistake, and it has the release agreement with the buyer's name scratched out as in terms of receiving back the earnest money, and the seller's name in there. So now what does the holder do? The holder has a release agreement with the earnest money going to the buyer that the seller won't sign. Then the notice sent that the holder is going to release it to the seller, and then the seller saying, nope, go ahead and give it back to the buyer. And then a couple hours later, the seller changing his mind again. stating that it was a mistake, that he misunderstood the form. His agent did not prepare another form, a proper form, or did not advise him to not do anything. At this point, there was nothing that either of the parties had to do other than wait the 10 days unless the buyer was going to make an objection. So now what does the holder do? We clearly do not have a meeting of the minds on this release of the earnest money. And at this point, again, the holder has every reason to believe that the seller has been in touch with the listing agent, because at this point, that's the only way the public seller knows what's going on. So the holder decides to, based on this objection, so now we have, well, it's a mess really. So now what the holder does is the holder sends out another letter stating that based on all of this information and the documents, and the seller, by the way, sent all of this information not only back to the holder but to both agents, and the buyer's agent shared that with the buyer. So now the buyer is aware of everything that's going on. So now the seller wants the full, and it's $5,000 earnest money. The seller wants the full $5,000 based on the buyer's initial default on the contract. The buyer now wants the full $5,000 because we have a fully executed release agreement releasing the earnest money back to the buyer. So the holder at this point writes another letter stating that based on all of this information and the documents that have been signed and not signed and the notices and so forth, that the holder recommends that the buyer and the seller agree to split the disbursement of the earnest money, $2,500 and $2,500. Should the buyer and the seller agree to do this, then the holder needs to have this back in writing by, there was a certain date. If not, then the holder will interplead the full $5,000 into the registry of a court for a judge to decide. When the holder interpleads the money into the court, the holder is entitled to take out the costs, the fees and the costs related to interpleading the funds, which is attorney's fees, so forth and so on. It can be anywhere from $800 to $1,250. So that comes out of the earnest money anyway. Holder sends this notice back to the buyer and the seller through their agents. A few hours later, immediately the holder receives a copy of, from the buyer, a mutual termination release signed by the buyer stating $2,500 to buyer, $2,500 to seller, signs it, sends it to the holder, and sends it to the listing agent. This is from the buyer's agent. A few hours later, the holder receives another email directly from the seller. Again, very, very upset. Upset with the holder, asking how can the holder even make the decision regarding the disbursement of the earnest money because the buyer defaulted by not terminating under the financing contingency, didn't meet the terms of that. Also very, very upset with the listing agent for not advising him, number one, to not do anything, or number two, for the listing agent to not have rewritten a new release agreement releasing the full earnest money to the seller. So the listing agent is very upset, ranting and raving, upset with both brokers, with the buyer, upset with everybody at this point. A couple hours later, the holder and the buyer's agent gets back the fully executed mutual release agreement. Lesson to you, from a broker to you as the agent. Here's the lesson. Number one, make sure that your clients completely understand the earnest money and what is at risk if they do not fulfill the terms of the contract, and the fact that the holder does have the complete contractual authority to interpret the contract and the circumstances regarding the termination of a contract. And if there is not agreement between the buyer and the seller in writing, i.e. on a release agreement, then the holder does have the authority to make an interpretation and choose to disburse the earnest money based on that interpretation. Or if it does get legally complicated, then the holder does have the authority to interplead the funds into the registry of the court. That's number one. Make sure your clients read the contracts, know what's in there, specifically know what happens to the earnest money if everything does not close as planned. Number two, so the question is, why didn't the buyer's agent get the know what was going on with the loan? It was a 22-day financing contingency. Why didn't the buyer's agent know what was going on with the loan prior to 22 days? Well, the buyer had brought their own lender. It was a big bank. The buyer's agent had tried to get in touch with the loan officer. The loan officer would not speak directly with the buyer's agent. The buyer's agent strongly impressed upon the buyer the importance of getting an update regarding the loan, and then when the loan was not going to go through, getting this loan denial letter prior to the end of the financing contingency. So in broker to agent, you guys have got to stress the importance to your clients, especially now with TRID and CFPB into effect. Communication with the lender is going to be more difficult for you as the agent. You guys have got to stress the importance to your buyer of staying in touch with the lender, knowing what's going on, knowing the status of the loan, and keeping in mind your time frames, especially the financing contingency time frame and the appraisal contingency time frame. Hopefully that helps you guys. And again, I'm Dana Sparks, broker with Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.